All right, we will start today's class. Hope I'm audible. If I'm not audible, please stop me. Okay. So we were in the middle of contract law. Okay. Today we are going to see contract of agency. And this topic is quite important because if you analyze the questions that UPSC has been asking under contract law, it is asking questions in an in-depth manner. It is not easy. Okay. We may think that contract is very easy. Of course, it is one of the easiest subjects, not very hard. But UPSC is taking it very seriously and making it a point that it will ask a lot of in depth questions. So you can think that, okay, I'll omit most of the in depth areas of contract and I can go ahead with the other areas. No, that's where you lag behind a person who is clearing UPSC. Okay, so if you're going to omit any areas that to contracts, it is the biggest blunder. Remember, UPSC law optional is not very fancy that we can get more than 300. 300 plus score is almost very difficult. Okay, because we have not seen anyone getting it, but we have seen people who have touched till 300, and also it is a very reliable optional. It will not leave you behind. We have AIR 1 with UPSC Law Optional 4, 7, 33, 14. A lot of people getting a lot of good marks, good ranks with UPSC Law Optional. And it is the most reliable. You're not going to fail just because you're having UPSC Law Optional. It can help you pass very easily. But this can be done only when you cover most of the important areas. That is, almost cover all the areas. That too, in contract law, you have to know the in-depth areas also. On that point, today we are going to see agency. Okay, contract of agency. Starting with who is actually an agent? We all will think a person who is acting for us or a person who is doing any work for us is our agent. Oh, it's not so. See, a servant is also working for us. Maybe we have a maid, a couple of house help. Instead of you cleaning your room, instead of you cooking something, your maid is doing all these things. Whether we can call that maid as your agent, no, they come under the head of servant. So the keywords for defining agent is very, very important. So one acting on the behalf of the other is the common meaning of agent. But legally speaking, any person employed to do an act for another represent another in third party dealing. You're doing some act for me, which means you're not doing as my servant. You're representing me. You go and sign, it means I have signed the contract. If my agent goes and says yes for something, it means I have said yes. If at all my agent is collecting some money, it means I received the money. Okay, so he will replace you. He has complete authority to create legal changes for you. Okay, he's not just a servant, he's representing you. He has the authority to create a legal relationship, to terminate a legal relationship. He has the authority to change the courses in legal relationships. That is the main thing about the agent. So, who is the agent is defined under section 182. Okay. Next, who is the principal? The person who is represented. The person, the kingpin for whom the agent acts is the principal. Simple as that. Okay. So now, this if this relationship exist, that is called as agency. Simple as that. So one person who's going to represent you, who's going to do the act for you, who's capable of creating legal relationship is called the agent, and for whom he is acting is called as a principal, and the relationship between these two people is called as agency. Okay, just like that. Now, with this very small meaning, UPSC comes up with a question. An agent is a person employed to do any act for another in dealing with the third party examined. So they're just asking the definition of agency, making it as a statement, and asking you to write the answer. Okay, it's very, very easy. So you're going to say what is agency defined and who can be an agent, who can be a principal, and all those things you say, and differentiate from servant and all. That will be your perfect answer. Okay, so who can be a agent? 184 gives that. We all will think only a major can be an agent. No, anybody can be an agent. A minor can be an agent. Okay, so it is not that only a person who is competent to contract can be an agent. You see section 184, it says anybody can be an agent. But the person who is competent to contract only will be responsible. So in case I am having an agent and that person is a minor, if something happens, I cannot hold the minor responsible. If I have a minor agent, I cannot make him responsible. So you have to see the two things. Anybody can be an agent. That anybody will not be responsible. Only those persons, agents who are competent to contract can be made responsible. Which means even an insane person can be an agent. Whatever he do, he's not responsible. Only I will be responsible. So there is no bar for having a minor as agent or an insane person as agent. Anybody can be an agent. Only thing they won't be responsible. Only the person who is competent to contract will be responsible. That is the thing. Okay, there is no bar for agent. Like you have to be like this, that. No, no bar at all. Now coming to who can be the principal. Imagine a minor can be a principal. See, agent also minor, principal also minor. The third party, what he will do? Who he will sue? Okay, in case of any problem. That's why under 183 it is clearly given that major person, any person who's competent to contract, who's having a sound mind, can be a principal. So you see the thing, agent, anybody can be an agent, but this anybody cannot be made responsible for any problem. So who will be held responsible? Only agents who are competent to enter into a contract can be made responsible. Then who can be the principal? 183 comes in. It says that who is competent to contract, that is like who's major, who's of sound mind, alone competent to be a principal. Okay, that's what it says. Hope you got the point. Now, coming to diving deep into the concept of who is agent, because this is where question crops up. Okay, so agents are representative capacity coupled with, see, agent is a person actually who is having this representative capacity, and also he has the power to affect the legal relationship of the principal with the third party. That is the key. If that person is able to represent you and that person is able to change the legal relationship of you, then he is an agent. That's where the difference between the servant and agent exists. Okay. So, changing relationship can be like creation, modification, termination of a contractual relationship, or something like that. Okay. He has the capacity to create a legal relationship also between the person and the third party. That was clearly given by the Supreme Court in this particular case law. So, if I have an agent to run my business in Calcutta, now I give complete authority to the agent. Now he can enter into an agreement to purchase the products, sell the products, go to the port, export something, all in my name. Okay, he can create legal relationship like that. Okay. Now, what is the difference between the agent and servant? If you talk about agent, you don't control everything. You give the authority and you say what should be the object to be achieved. Say, for example, running a business. See, you won't say that you have to come to office at this time, leave at this time, and this is your tea break. When you are contracting, you can contract only in the morning. No, you will not micromanage. But when it comes to the servant, we are having a high control. You will lay down what are the rules comparatively. Okay. Next, Agent can create a contractual relationship, whereas servant cannot create one. Whether a servant can sign instead of you, maybe in a courier. That too, he will not sign instead of you. He will sign in the capacity that he received from your home. That's all. Okay. Next, work for several principals. Yes, a single agent can work for several principal, but mostly a servant will have only one master. We think like that. Earlier only there was only one master, but today my domestic help work in 5+ houses. That's how they can survive. Okay, that is different. But I'm generally telling a servant can mostly will have only one master. Okay. Next, whatever remuneration we pay to the agent is called as a commission. And when we pay the same remuneration to the servant, it is called as wages. Okay. Next, if any problem is committed by the agent within the scope of authority, the principal will be liable. And scope of authority, what all I authorized. In between, he has done something, but not a criminal act. Maybe some civil wrong or something he does, or something he acts in a good faith and ends up spoiling other people's property or something. I have to pay the compensation, provided it is within the scope of authority. And when we talk about servant, there is no scope of authority. We call it as scope of employment. Master will be liable when servant does any fault within the scope of employment. So, to decide whether a person is agent or not, we do have a test. It is given under this case law. It says that even though the name may sound as agency, you have to see the duty and relationship, whether the other person can represent the principal, whether he can create a legal relationship. All these things you analyze, and if it is yes, then it is an agency, immaterial of whatever name it is given. Okay, so the duty and the relationship is the entire concept and core of agency that you have to know. Okay, next, we have different types of agent. We have this factor. Who is a factor? We will go entrust that person with the goods. This person will sell the goods and give us the money. Today we have a lot of thrift shops where we will be like you have, see, say for example, for a marriage you have got a one full lehenga, and this lehenga cost up to some 40,000 and 50,000. Okay, you wanted to have that, and you had that, and how many times you're going to wear it? Rarely, right? Maybe once for your reception and one more time maybe for your brother's wedding. That's all. Even that happened for me. And I didn't purchase for a 40,000, 50,000. My lehenga was 15,000. And that also I feel very heavy-hearted nowadays. I could have bought three very good outfits with that. Right? It is sleeping and it is not even fitting me nowadays. Okay. So what we can do, we can give it to a thrifting shop where they will sell it to someone and give money to. Okay, like that we have to teach you. That's what is called as factors. Okay, you can interest the good, the possession you give, the goods possession you give, they will sell and give you the money. Okay. Next, we have the brokers. Say, for example, you have to buy a very beautiful house. You go search in the internet and get the builder and go for the big house. It's okay. But most of the time, we end up with the brokers. The brokers will hunt for the house and they will try to make our sale happen. Okay. So, what they basically do, they are also agent. They are not going to have any possession or something. They are going to negotiate the sale and hire and purchase of a good. They are not going to have any possession like the factor, but they are just going to negotiate between the buyer and the seller. They are called as brokers. Next, we have the del cadre agent. Who are these del cadre agents? They are, see, actually, they are very poor souls, I would say. Okay, the reason is they will ask for extra payment. Why extra payment? They will negotiate, and to increase the trust, they will say that if the party I brought does anything wrong and breaches the contract, I will be responsible for you to compensate. See, they are only negotiators. But in case the party they vouched for did breach any terms of contract, now he will pay you the compensation for certain extra remuneration from the parties. Okay, so they are called as del cadere agents. Just for extra commission, they are putting their head inside the gelatin. That's what is happening. Now, coming to another UPSC question, no consideration is necessary to create an agency. Give reasons. Yes, you have to quote section 185. It says that no consideration is necessary to create an agency. If you talk about consideration, you have to definitely talk about section 25. Section 25 alone says that if there is a contract without consideration, it is void. So section 185 is an exception to section 25. Okay. So for creation of agency, you need not give any consideration. Nothing is required at the time of creation. This doesn't mean that agent will not have any remuneration. He will have remuneration. At the time of creating the agency, consideration is not necessary. Later, I mean at the time of appointment, later you can pay remuneration. Okay. Coming to how an agency is created, we have various modes of creation of agency. One very common mode is given under 186. It's express physical appointment. That is express appointment by the principal. Now I go this and write an agreement and say you are my agent. Only that is express appointment. No, it can be a written one like the document created, or it can be words spoken. If I am telling something, expressing something, that is express way of appointment. I say so and so Mr. Ankush will be my agent from tomorrow. He will be representing law experts in all the financial transactions. So all the students will be paying to Mr. Ankush. That's all. If I say that or write it, it is express mode of appointment. Next mode is implied appointment by the principal. See, from the conduct you assume, from the conduct you assume that he is your agent. Say, for example, like I'm sitting in the office and there are people coming for admissions. I have a person in the front desk and he is Mr. Ankush. What he is doing is collecting all the payment and giving the vouchers. Seeing that and keeping quiet, I didn't say anything expressly. I didn't say, Ankush, you are the agent, you are doing this. No, no, I never told anything. Whenever he acted, I'm quiet, I'm allowing him. So, by the conduct, I'm creating an agency, or I'm just telling Ankush, take care of all these things. That's enough. Okay, by my conduct, I'm allowing someone to be my agent. It is called as implied appointment. Okay, I have a small example here. You can read it later. Now, coming to another type of agency is agency created by necessity. It is not that me saying the situation is making you do something. Okay, so let me tell you this case law. What happens? There will be a lot of butter, kgs and kgs of butter transported through railways. And suddenly, unfortunately, there will be a strike of railway employees or something. Some riot is going, so the train cannot move. Imagine what happens to the butter, that too in Indian temperature. I think it's not India, maybe UK case, but there also how long the butter will be good? It will get spoiled, it will melt away. Okay. So what happens? Immediately the railway company will calculate all the perishable goods and it will sell it. So now I have sent my butter. Did I give the railway company the authority to sell the goods? No. But it is necessity. If it did not spot and sell the goods, I will be at loss. So for my good, because of the necessity, suddenly railway company became my agent and it is doing what is necessary as an ordinary prudent man. Right? So there we create agency by necessity. Reason one If, say, for example, we are not able to communicate to the principal, there is no time to ask. Some immediate action is needed to prevent the loss. Then, at these times, this agency by necessity is created. Another example, what happens in this case law, a man will attempt suicide and he'll be like struggling for life. One surgeon will see him and immediately takes him to the emergency ward and operates to save him, and he saves him. And after saving the person who is like alive now, once attempted suicide, now he is alive, he will he will tell to the surgeon that I cannot pay the expenses that you incurred because I didn't ask you to save me. Now the court told, no, no, like an ordinary prudent man, it was necessary to save you. The surgeon has rightly acted. He has become your agent under necessity. So you have to pay him. Okay, like that it will say. Now, coming to the next thing, that is agency by estoppel and holding out. Whatever we are seeing here are different types of implied agency, not expressly created. It is all implied. Under implied agency, we have all these types. And the next type is called as agency created by estoppel or holding out. It is given under section 237. I told you, right? You will keep quiet when the other person acts. You allow others to believe that he is your agent. Okay. So in this case, what happens? There'll be a purchaser who will be allowed to have a hemp in his custody. See, this is not much important. I'll give you a classic example, same example, where I am sitting there in the office and in the front desk, I have a person. He's collecting all the money. I'm seeing that. I'm not telling anything. I'm happily allowing all the students to give all the money to him and all the stuff. Okay. Suddenly, a student comes and says that I have paid money to so and so, Mister, and now your team is asking me to pay the next installment. But I have just paid it last time. To him only I paid. He is asking like that. The student is asking like that. Now I say that, why did you give to the front desk person? He is not the authorized person to collect. Can I say that to the student? Because within my knowledge, another person was holding out to be my agent. He was asked, like, act to be my agent. I did not stop that person. I silently accepted his action. What others will think, yes, Malti ma'am knows it. That's why the other person is getting all the money. So you will believe and you will pay. Right? You will not doubt anything. Now suddenly I jump back, go back and say that, no, no, why did you give it to him? I don't know that person. I am stopped from doing that. So this is called as agency by estoppel. Agency created by estoppel. Principle, allow a person by conduct or conduct that third party is believing that this person is an agent and acted on it. Later principle is stopped from denying because the agency is already created by holding out and estoppel. Okay, that is the thing. Now, immediately I should react. Later point of time, I should not deny something which I held out to others, showed to others. Okay, that is the crux. Now, next question is whether there is agency between wife and husband. In fact, to clearly ask whether a wife is an agent to the husband, not vice versa. Once see, yes, in law, wife is regarded as an agent to husband, not vice versa. When hearing that, I was like very irritated. See, I will be my husband's agent, but he will not be my agent. He will be my principal, it seems. It is inequality, right? When I heard this per se, I was agitated. But you have to analyze in depth. So, what I can do? I can borrow money everywhere and I can run away. And for me borrowing the money, who will pay it? If I am the agent for my husband will pay it. This sounds to be beneficial, right? So why would we worry? Okay, so we have a UPSC question on this point. Even judicial service also ask these types of questions in MCQs. Whether wife is an agent for the husband. Yes, when they can be an agent if they are living together, they are not merely living, they are living in a domestic establishment. Okay, so in this case law, what happens? The wife and husband will be managing a hotel together. In this same space, they will be living. The wife will get all the money and she will run away. And the opposite person will say that they are husband and wife, they are living under the same domestic household. So, whatever money the wife has asked for, that is, got the money, the principal husband must pay. The court will say, no, they are managing a hotel which is a commercial establishment. No domestic establishment of home is right there. So, although they are husband and wife, they are living together. Since it is not a domestic establishment, the husband will not be the principal for the wife. That will be the ruling. Okay, so you have to remember that. So, what all he will be liable for, husband will be liable for is basically liable only for the necessities. So, I get 2 lakhs to buy an LV bag, and I get 3 lakhs to get another type of bag, maybe a Birkin for 25 lakhs. Those are all not necessities. Okay, so I borrow money to feed myself, to for my clothing, for a roof, for my education, for my child's education. All those things are considered to be necessities, and my principal husband will be liable to pay that. Okay, so all these points are quite important. Now, coming to the third mode of creation of agency, it is by ratification. Ratification means initially there is no authority to do. Later, it is accepted. That's what is called as ratification. Say, for example, you wanted to study abroad, so you apply to a university, and your parents don't approve for that. They will say, why you don't apply for anything? But without your parents knowing, you have applied for Harvard or somewhere, and finally you got the seat. You go to your parent and you tell them, they may accept. This is called as ratification. Initially, you don't have authority, or you have exceeded your scope of authority, but later the principal says, yes, that means he is ratifying your action. It is given under section 196. When it will arise? Without the knowledge of the principal or without his authority, expressly or impliedly, you are doing something. Later, he expressly or impliedly accepts your act, then that is called as ratification. Okay. So, say for example, there is in this case law, there will be a manager. Okay. It is an insurance company. So, he doesn't have any authority to accept insurance and assure something. Because, see, every insurance will have terms and conditions. So he has no authority, he just assured without authority. So the person who claimed the insurance came to the company for the money. Now, after knowing everything, even though the manager did not have the authority, the company having a good belief or something, good heart, company will not have heart, but say the persons working there are having a good heart. So what they told that, yes, company accepted the money of the policy and told that we will assure it. So now what the company did, it did ratification. So my manager doesn't have any authority to accept, he has accepted. Later company came to know about all these faults. It said, okay, we will accept your money. We are okay for the policy. In case of any problem, we will repay you as per your terms. So this acceptance is called as ratification. So that's why it's called as ex post facto agency. Acceptance given somewhere else, and the agency is accepted by the authority only at the later point of time. The wrong acceptance act is done, the fact of act is done first, but the acceptance is given later. So that's why we call it as a ex post facto agency. Wait a minute. Wait a minute. 1 second. Where did my, I can see only a blank screen. 1 second. Okay. Next, we will see the essentials of ratification. Okay. So, first thing is it must be done on the behalf of the other. That is, the agent must be representing the principal. If he is acting on his own authority, the principal cannot ratify because he is acting for himself. What happens in this case law is that the principal will instruct the agent to buy the Karachi wheat. Specifically, he will say, but the agent will go and buy Durant wheat. Okay, and that too at a higher price, and he will think that my principal will accept it, and he has done it. Okay, now he has, while buying the wheat, he signed only his personal capacity. He did not sign as an agent. He did not represent the principal, mention the principal at all. Now, whether the principal can ratify, he cannot ratify. So, ratification comes in only when one person acts on the behalf of the other person. If he acts for a fictitious person in some other person's name who's not at all existent, or acts only in his personal capacity, then he is not acting as an agent. Then the principal cannot ratify it. Okay, that's very, very important. Now, there is a question on ratification. They will ask what is ratification and what are the essentials of ratification. And they ask that with a state-based question. And this was taken from a standard book. So Lord James has given this statement. Read the statement. It is a previous year question. And they have culled out the exact statement and asked a previous year question. So what you will say, it was given by Lord James. And this is the statement given. Now you say, what is ratification? Here I have given it to you. What are the sections involved? What is the other name? Ex post facto agency. Now we are jumping into the essentials of ratification. First one is on behalf of a person, and you on the behalf of the other person, you should have acted. So you explain that and give a case law for the same, and then you go to the competency of the principal. Say, for example, while the agent is acting, the principal must be competent. Then only the question of ratification comes. So, say, for example, there is an agent acting for myself, and at that time, I have gone insane or something like that. Okay, whether he is acting on my behalf is valid. Okay, when the agent is acting, the principal is dead. Whether the agent's act can be ratified? No. There are cases, it's very, very unique case. What happens? A person will be contracting on the basis of a company name, but when he is contracting, he'll be acting as an agent for a company. But that company, when he is acting, that company is not yet incorporated, not yet created. So it was just an idea to create it. When the idea came itself, he will go and contract in the name of the company. The company will be only created after the action. Whether it can be ratified, it cannot be, because at the time when the agent is acting, the principal must be competent. He must be existent. The company was not existent. So ratification is not at all possible. But we have an exception. If they are entering into see, they are create company. The agent is acting to create company, incorporation of a company, that is okay. Other than that, if he is signing in the name of the company where the company itself is not created, then ratification is not possible. Okay, next, act should be lawful. Yes, I am a principal. I can ratify the work of my agent. Now my agent is going and robbing all the houses, hitting all the women. Now, whether I can ratify and say, okay, I accept this, don't worry. No, it is offense against the state. Okay, so ratification is not possible when a third party is damaged. You create some crime. Okay, in this case law, what happened? A mining company was illegally terminate the employee. Whether this termination actually the removal is per se illegal, and later the company will ratify the removal. That cannot be done because it is damaging the third party, illegal one. Who are you to authorize something illegal? Although you are a principal, that cannot be done. Okay, that is the thing. Next, when the principal is ratifying, he must know all the material, full defects, full knowledge must be given to him. After knowing everything only, he must have ratified. Say for example, I I sold the goods for 10,000 rupees. I go to my principal and say that, sir, you did not give me authority, but I sold the goods for 10,000 rupees. And he feels that, yes, good, you have sold something for 10,000 rupees. I am proud of you. And he ratifies it. But what is the good if it is an iPhone? Selling a 1 lakh worth iPhone for 10,000 rupees, whether it is right. So it will be an invalid ratification. So what is the point? While the principal is ratifying, saying yes, accepting the agent's work, he must have the full knowledge about what has happened. Only after full knowledge, he is saying yes, that ratification is valid. Okay, that is the fourth point. Next, you have a doctrine inside this ratification, which is called as doctrine of relation back. What is this relation back and all? Oh, it's very simple. See, I told you there is a company where the manager does not have any right to sign, but he signed. Later, the company accepted. So when the contract came into life, only when the company accepted? No. When the agent signed, when the agent acted, although he doesn't have any authority, when the point he acted, from that point, the contract starts. So this is called as doctrine of relating backward. So he has acted first, which is without authority, the agent has done. Later, the principal accepts. So, from the acceptance of the principal, actually, if we say from that point of time, the contract must start. Legal responsibility must start. Not so. It will date back, relate back. That's what is called as doctrine of relation back. If you are ratifying from accepting point, it is not created. It is created from the point where the agent acted. Okay, that you have to know. Okay, that's what is doctrine of relation back. Now for that we have a case law. Whatever I told, that's what is given in the case law. You can read that later. Next, see, if you are ratifying any act of the agent, it will, if it is having a series of action, you cannot accept one part of the action and deny the other part. Say, for example, my agent has sold my goods for same 10,000 rupees. Now I have to give the goods. He doesn't have any authority to sell itself. Now he has sold. So what I will say is, I will ratify only half of his act. That is receiving the money. Now, delivering the goods part, no, he doesn't have any authority. So I will cancel that. I will ratify only the part that is beneficial to me. Whether I can do that? No. A ratification of a particular act, transaction, must be done for the whole transaction. Partial ratification only taking the benefit is invalid as per section 199. Okay. Now, see, we are actually seeing the mode of creation of agency. So we completed express one. Under the implied one, we saw necessity, we saw ratification on all those stuff. So ratification all completed. Next, fourth mode is that agency created by operation of law. Because of law, agency will be created. How? We have the partnership act, right? Exactly, your UPSC law optional topic will say formation and dissolution of partnership. So as per the Partnership Act, if you are a partner, you are mutual agents to each other. So in the Partnership Act, are you telling you are an agent? No, you are just entering into a partnership. That's all. The law is positioning you as an agent to each other. So the law itself creates an agency that is called as agency created by law. Best example is partnership. Okay. Now we have created the agent and all stuff is right there. Now, what is the duty of this agent? It ranges from 190 to 218. Do remember the sections that where you will score more marks. Okay. First thing is to obey the principal's instruction. Next, exercise due care and diligence. You should have the proper skill for what you are appointed. You must do justice. Next, maintain accounts. Then deliver all these sums that you receive on behalf of the principal. So, if you are collecting any rent, that is your duty. You collect all the rent, and what you must do, you deliver the lump sum to your principal. You have to do that. But in case you have some remuneration to be paid, now I have to collect some 50,000 rent. I am collecting everything. My remuneration is 10,000. What I can do? I will take my remuneration 10,000, deduct the sum, and I can give the remaining 40,000 to my principal. That I am allowed to do. Okay, as per these sections, you have to know. Next, whatever is happening, I must communicate to the principal. Suddenly, my building collapses. I am authorized to collect the rent, maintain the building. Building collapses. I don't call the principal, but I keep quiet. One day, principal is calling me and asking, what's happening? Is everything fine? I say that, no, no, last week there was a flood and the building is gone. Oh, but the principal is boiling there and asking, why, damn, you did not tell me. And I will say that you did not call me, you did not ask me. I cannot tell that. It is the duty of the agent only to communicate to the principal as per this section. Okay, next. He should not let his own interest conflict with his duty. Okay, duty is first for him. Next, he shall not make any secret profit. Now, I will collect the rent. Instead of giving 40,000 or 50,000 to my principal, I will make a secret profit of some 10,000 and give the remaining. No, that cannot be done. Okay. Not to disclose confidential information or documents. Principal has given something confidentiality. You have to maintain that. Next, you cannot delegate your authority, which means you cannot have sub agent. That is the general rule. But we will see a lot of places where sub agents are appointed. Yes, most of the places sub agents are appointed. Let me tell you the general rule first. As per section 190, agency cannot be given as a sub agent. Agent cannot keep a sub agent unless and until there is no personal capacity involved. See, if I am appointing a beautiful artist to paint a beautiful picture for me, and suppose maybe I have asked Shah Rukh Khan to perform something for the 100th year of, maybe I'm not alive at that point of time, my daughter takes up or something, and maybe Shah Rukh Khan also will not be alive. If some Khan who is very famous at that point of time comes in and we sign a agreement for him to come and dance. Okay. Whether he can appoint a sub agent to come and do that work. I have asked a particular painter to do a beautiful painting. Whether he can delegate his work, no, it involves a personal capacity, then sub agency is not allowed. And if the nature of the business is that it allows sub agent, at that point of time when there is no bar, we can appoint sub agent. Say, for example, we have a person who is operating like different garages, car repair garages at different position, different places. He cannot go and be present at every garage. He cannot repair every car. Physically impossible. So nature of business is allowing to have sub agents. Okay, at that point of time, they can have sub agents. So generally, the agent cannot delegate his authority as per section 190. Delegation is allowed only when it does not involve personal capacity or the nature of business allows the person to have sub-agents, then only he can have sub-agents. Okay. Now, who is a sub-agent? So, regarding sub-agent, first you have to know 190. There is no sub-agent, generally no. But he is allowed only when the nature of business allows and there is no personal capacity is involved. And even the principal allows the agency to have a sub-agent. It will be expressly mentioned, then you can have. Okay. Now, who is a sub-agent? An agent appoints a sub-agent. So basically, sub-agent is the person appointed by the agent. Okay, that is the thing. Now we have to see the responsibility of the principal with the sub-agent and all those stuff. But we are listening to classes for past 50 minutes. So I request you to take a small water break for me also. Okay. So we'll take a 10 minutes break and jump back at 6 o'clock and we will complete the class by 6:30. Okay. So we'll get a small break. So, right. We will start the class. Yeah. We were right there talking about the responsibility of the principal in case of sub-agency. Okay. For that, we have to read section 192 and 193, which is very, very important. Imagine this man is the principal. Now he is appointing this woman. She is the agent. Now this woman is appointing this curly haired diva, who is the sub-agent. So principal, agent, and sub-agent. How the responsibility runs in here? Whether the principal is responsible for the acts of the sub-agent. That is the question. For that, we have to see section 192. It says that if the sub-agent is appointed properly within the authority, the principal within the authority, then the principal will be liable. What does it mean? If the principal accepts within the authority given by the principal, if the sub-agent is appointed, then he can be made liable for the actions of the sub-agent. But in case the principal did not give any authority, what will happen? Imagine this person, this innocent man here, although he is a principal, he did not agree for a sub-agent. He did not give any authority to this woman to create a sub-agency. Beyond the authority, now she is creating a sub-agency. Now we cannot hold the principal liable here. How the system works here? It will be that the sub-agent will become the agent of this person. This agent will be the principal. So the first principal will not come into picture at all because he did not give any authority to create a sub-agency under him. So what happened? If agent is creating a sub-agent against the principal's authority, then whatever the sub-agent does, the agent alone will be responsible because she will be the principal for the sub-agent. Like that. Okay, that is given under section 193. Now, that's what I have told now is repeated here. A principal, if the authority is given also, the system works like that. The principal will appoint the agent will appoint the sub-agent. So if it is done within authority, now let me change the drawing tool. Yes. If it is done within the authority, then whatever the sub-agent does, the principal will be responsible. That is the thing. Now imagine about the answering, see how the hierarchy runs. The sub-agent will not directly be liable to the principal. The sub-agent will not directly answer to the principal. He is not below the principal because he is appointed only by the agent. So he will answer only the agent and the agent will in turn answer the principal. The hierarchy runs like this. Okay. So you see the scenario, if the sub-agent is appointed within authority, the principal will be directly liable for anything the sub-agent does, but in return, the sub-agent will not answer the principal. Otherwise, he will answer only the agent. The agent only will in turn answer the principal. That is the hierarchy. But there are certain situations the sub-agent will be directly held liable to answer the principal. When he is doing some willfully wrong, doing some fraud, then he cannot run the show by telling that, no, principal, you cannot ask me, I will answer only the agent. No, you have done something willfully wrong. You have done something fraud. Then the principal can directly ask the sub-agent, and the sub-agent will be responsible to answer the principal. Okay, so that is the thing. Now, what is the principal's duty? We saw the agent's duty. Now we will see the principal's duty in this section range. First duty, you have to pay the agreed remuneration. Whatever money you promised, you have to pay. But if the agent is guilty of some misconduct, he is creating some loss to you willfully. Now he need not pay the remuneration. Okay. Next, you shall not hinder any earnings of the agent. In case, say for example, I tell to the agent that you secure a lot of deals for me. If you're securing any lot of deals for me, I will give you 10% as remuneration. Now he is securing a lot of deals for you. You feel that, I have to give 10% as remuneration. So I will cut off all the deals. You are hindering the earning remuneration commission for the agent. That you shall not. Okay, next. In case during the duty, in case within the authority, the agent has done some act and it has resulted in the loss for the third party, it is the principal's duty to indemnify and reimburse. Only when it is a lawful act, he does a lawful act, but it results in the damage for some other person. Yes, you have to fully cover it, reimburse it. He has done a civil wrong. In a good faith only he has done it, but it affected the third party. Principal have to compensate, he is liable. But in case the agent is doing some criminal activity, how the principal will be liable unless and until he is also lending a hand inside? Unless and until he knows something criminal he is doing and he says, yes, do that. Unless and until he is also involved in the crime, he will not be liable. Okay, so in case any criminal action is done to the third party, principal shall not indemnify the amount. It is given under section 224. Okay, now we are going to see the rights of agent. What all right he has? He has the right to retain sums. We already saw, right? That is, agent can collect any remuneration or something, any amount on behalf of the principal. While giving the amount back to principal, submitting, depositing it, he can retain any amount due for him. The agent can do it. That's what is given under section 270 and 280. Next thing is the right to retain property. Say for example, again, I am an agent of you. My duty is to maintain a property. So you have to give me monthly some 5,000 rupees. I have worked for 5 months, so you have to give me 25,000 rupees. I'm maintaining it. I am spending cost for cement, patching it up, patchwork I'm doing, everything. But you're not giving any money. That patchwork also amounts to some 10,000 rupees. Now 35,000 rupees is due from my principal. Now my principal is telling, it's okay, now you give the property to me, hand over the property to me, give the keys to me, I will take care. I can say that, no, I will retain the property until you pay me the due. You pay the 35,000 rupees and get your property. That I can do. Okay, next. Termination of agency. We all saw how an agency is created, what are the rights, who's an agent, everything, even a sub-agent. But now we are coming to the end. How an agency can be terminated? By agreement, clean and simple. I write a mutual agreement that by orally or written or some way that agency is ending today. I don't want you. You don't want me. Something like that. We are ending today. We write an agreement, either writing or orally. Then that is like agency is terminated. by an agreement. Okay. Next, but we see that is like in agreement we have a lot of types also. That's not important, but first way is by way of agreement. And next we have by the act of parties. Say for example, we have created an agency to do a particular act. I have called a painting agency to paint my house for this Pongal. So they started the painting work. They are doing it. Maybe I have a very big house and they are taking some 20 days to paint it. Once it is completed, once the performance is done, agency ends. So by the act of parties, when the specific purpose for which agency is appointed is completed, agency ends. Next, revocation by the principal. Same case. I have appointed a person for painting my home. What they do is they bring small brushes and they're not painting properly. Here somewhere white, here somewhere green, whatever color I told, they are painting in their own wishes. Now, what I will do, I will say that, Appa, why did I actually call you people? I will revoke it. You need not do it. So, revocation by the principal is also possible. But in case of agencies where third party relationship is involved, like, say, for example, I'm keeping an agent to maintain my finances. And this third party will talk to all my students and get the periodical payment or something like that. Now, if I'm entering the financial agency, I have to inform the third party. If I don't inform the third party, what they will do? They will continue paying to the my agent, thinking that he is still there in work. Okay, so in case of any revocation, I must inform or give notice to the third party. Okay, next, renunciation by the agent. It is not that only the principal can revoke. The agent also can get fed up and say that I don't want your agency. You are not my principal. So imagine the same thing. I have asked the person to paint my house, even painting my nails sometimes. What I will do, I will first ask for red color and put that red color in my nail. And then I say, no. Red color is very, very flashy for me. Bring some other color. And then I continuously re-choose this. What the other person will tell. Same applies for the house. I say white color. Then I change to gray. Then I say, no. Green is prosperous. Paint it green. What it will look like, I don't know. So I say paint it green. Okay. So if I do all this, the agent will run away. So the agent also can renunciate the agency. Okay, that is also given. Next, agency by notice. This is what is like you want to end. One way is like you give a notice and reasonable time to end. That also can be done. Okay. Next, by the operation of law. The law itself, one second, the phone, it's fine. The law itself will terminate the agency. How? Either person is dead. Either the agent is dead or the principal is dead. Where we go for agency? No agency. Next, by insanity. Either the agent, mostly the principal goes insane, the agency ends. Okay. Next, bankruptcy. Actually, an agent can be an insolvent, bankrupt person, not capable of being entering into a contract. Because anybody can be an agent. Only thing he will not be held responsible. So the agency will end when the principal goes bankrupt. That's very important. Okay, insolvent. Next, if the principal is a company, agent is a company, if winding up has done, if the company is closed altogether, the agency will end. Okay. And finally, we have this most important concept repeatedly asked, which is called as agency coupled with interest. You appoint an agent, that agent will have a legal interest in the subject matter personally. Okay, so let me give you an example. Say, for example, Nandita is a land broker or something. She's selling high profile lands and she's very busy, some sort of thing. And now I owe Nandita some 5 lakh rupees. Now she's asking me, hello, ma'am, you told that you will give me the 5 lakh rupees, what I gave to you, but you're not giving it to me. And she's asking me again and again. Now I say, Nandita, I don't have money with me. So, but I have one ground. Only one ground, that too. In Ananagar. But that's very difficult to get here. Really, that too in Ananagar, it's very difficult. Okay. So I'm having one ground in Ananagar in Chennai. So I'm telling Nandita that, see, you are a very good land dealer. And I come up with an agreement. You be my agent. You sell this land for crores and take your 5 lakh rupees, your remuneration also percentage, and return money back to me. Now, yes, Nandita is my agent appointed. What Nandita is having? She's having a legal interest in the subject matter, because only when she sells, what she can do? She can get the money. So this is called as agency coupled with interest. That is given under section 202. Now the problem here is whether I can stop this agency at my wish. I will say that, maybe after my death, will the agency end? No, it will not end, because it is not just an agency. It is something coupled with interest, a legal right she has. Her interest will be affected if I end it. That's why in this case law, it is specifically stated that any personal benefit of the agent is involved in the agency, the authority is coupled with interest, it is not revocable. You cannot revoke it. Even after your death, maybe after my death, Nandita will sell the place. She will take the 5 lakh rupees. She will take the remuneration and return back what is mine to my legal heir. Okay, that will be done. So this is the case where a bank will be an agent to the person. He would have got loan from the bank. He cannot pay the loan. So what he will say? He will give a decree that he has won from the court, and he will say that, here bank, I will write the decree to you. Now you realize the decree and take whatever loan which is due to you and return the money to him. Now his death, or later if he wants to revoke, he cannot revoke it. Any agency coupled with a legal interest, agency coupled with interest, cannot be revoked just by the principal or by his death. That is the key concept which is given under section 202. Very, very important. Okay, so we have covered all the topics. Now it is your homework to cover who is an undisclosed principal, and you're going to talk about revocation of agency by undisclosed principal or revocation of agency. Is there any new rules that they have brought about? Okay, this one is quite little important. So do this as a homework, and you can send it in Law Experts MB WhatsApp, so I can check it. Okay, that you can do. So we have completed agency. If you have any doubts, you can ask
Can
me.
you repeat the homework?
Repeat which one? Homework.
Homework.
Okay. Yeah. You're going to see who is an undisclosed principal. Okay. What is the duty and liability of an undisclosed principal? Okay.
Okay.
And next, revocation of agency by a principal, whether there are any rules for such revocation. You can ask the chat GPT also, but chat GPT most of the times it will not give the right answer. You cross check it with all the books that you are having, so that while cross checking also we will remember a lot of things. By correcting people only we remember a lot of things. So that you can. Okay. Okay. Any doubts? Bala sir is having any doubt?
No.
No. Okay. Okay, we'll wind up and meet in next class. Probably this week we will be having a special class to teach you on answer writing. Okay, we'll have that class. Thank you.